I have moved into a different room. Hopefully now the echo isn't as bad. I've ordered a new camera. It should be here next week. Today's video is about the public charge ground of inadmissibility. The reason this is in the news right now is because a new policy proposal has just been released. We are in the 60-day comment period. After the comment period, then the government publishes a final rule. So the rule that's just been proposed is not in effect yet. This new policy proposal has been anticipated for some time. Early on in the Trump administration, one of his executive orders was to come up with a different public charge policy. There was also a version of the draft policy was leaked to the press a couple of months ago, and it was very strict, which got it a lot of press. This final proposal that has been introduced is not as strict, and for that reason, we're not really seeing the outrage machine that we normally see when stuff happens with the administration and immigration. First, let me go over a little bit about what public charge is. This is a part of immigration law that's existed since immigration law has existed. Congress has always sought to keep out people who are just going to wind up homeless or otherwise live off the taxpayers' money. One of the differences between this new proposed policy and the previous policy was that now they're going to look at benefits that have already been received in the United States that were not cash-based, and that would count against the applicant when they go to apply for either adjustment of status or they apply for an immigrant visa at the consulate. But I do have to say, unlawfully present immigrants don't qualify for nearly all types of public benefits, at least all types of means-tested public benefits. Also, not every person applying for an immigrant visa or adjustment of status is subject to a review under public charge. Asylees and refugees are exempt from this review. Also, for people who are coming on the employment-based category, most of them, it's presumed they're not going to wind up being a public charge because they're coming here because they already have a job. In order to get an employment-based visa, you have to have already proved, in order to qualify for the visa, that you are highly employable and that you have a job waiting for you. The public charge inadmissibility almost always comes up for the family-based visas and for the diversity visa lottery. Also, with the changes, not only are they going to start looking at previous use of public benefits more closely, they will also look more closely at other factors that could lead to a finding of inadmissibility, such as medical problems, limited education, limited English skills, etc., things of that nature. That is actually what the law allows. The law on public charge really has two sections, meaning it's a two-prong evaluation. For family-based cases, the sponsor has to file an affidavit of support showing that they make at least 125% of the federal poverty level for a family their size, a household their size, that includes the foreign national. If the sponsor doesn't have enough income, you can use a co-sponsor as well. In addition, once the person has proved that they meet that affidavit of support requirement, then what the Immigration and Nationality Act says is they do a second analysis. You meet that first one, then they do a second part where they make sure there's nothing about the person that's going to make them more likely than the average person, perhaps, to get public benefits. Well, really it says become a public charge, and it's never really defined what a public charge is. So it was always affidavit of support plus another review. That is not something that Trump is creating. That is actually in the law. Okay, so I looked at a number of articles on this, and the one that I think is most honest and most fair, believe it or not, is Vox. Trump is proposing a regulation that could change the face of legal immigration by restricting low-income immigrants. Immigrants could be barred from green cards based on use of food stamps or Medicaid. Having used public benefits won't automatically disqualify an immigrant from being able to get a green card. Also true, fair, good. They're saying that it's not an automatic denial. Later on, they say one of the oldest reasons for the U.S. to reject a would-be immigrant, right up there with the immigrant being Chinese, was suspicion that the immigrant was likely to become a public charge. They're giving some of the history. I don't know why they threw in a little bit of race baiting in there. I mean, basically what they're getting at is the fact that the regulation is old, doesn't mean it's right. They're referring to the Chinese Exclusion Act, but that was completely unnecessary. The Chinese Exclusion Act was thrown out a very long time ago because it was racist and it was unfair, whereas public charge has never been thrown out. So there was no reason to throw in a little bit of race baiting, completely unnecessary. Okay, later on, and we're going to skip around just a little bit, it says the irony is that most of the immigrants who are eligible for federal public benefits aren't affected by the new proposal. That's true, and that's a very important thing to point out. I'm glad they pointed that out. Most of the people who haven't adjusted status yet, or who haven't applied for an immigrant visa, aren't eligible for public benefits anyway, and those who are eligible, for the most part, are going to be refugees and asylees, and they're not subject to the public charge ground of inadmissibility. So they correctly bring up in the body of the article, does the use of previous public benefits in the analysis, is that really going to affect that many people? And it probably won't. So they correctly point that out. And then they go on to say the most certain effect of the new proposal, whether or not the regulation is finalized, is one that isn't in theory a purpose of the regulation itself. The proposal will almost certainly lead thousands of immigrants who aren't covered by the rule to forego public benefits that they and their families, including U.S. citizen children, are eligible for. Yes, I agree, but they are implying that the fault is in the proposal. I believe the fault is in the media, because here they are in the body of the article admitting that this stuff about public benefits is actually only going to affect a very small group of people, but that people will think that it's going to affect them, and so they won't apply for the public benefits. Well, why would they think that? Could it perhaps be that in the byline of the title of this article, it says immigrants could be barred from green cards based on use of food stamps or Medicaid? So it is the media that is leading people to believe that they're going to be denied because of previous use of public benefits. That misinformation is the fault of people like Vox, who are having bylines like this, even though they know, as they state later on in their article, that the people aren't going to be affected, that very few people would be affected by that part of the regulation. So why are you implying in the title of your article that everybody who's received these benefits is going to be affected? There are two other things that I take issue with in the Vox article. One of them is that they imply that the public charge ground of inadmissibility is an obscure ground. It states, public charge accounted for only 4% of denials in the 1940s and less than 1% after 1950. I think that's very misleading. The current administration can't decide what their policy is based on law from the 1950s and the 1960s. The Trump administration has to base their policy, they are required to base their policy on the current law, which was passed in 1996. So it says it was 1% after 1950. I suppose they're saying that includes now. Here's the problem with that. When somebody applies for adjustment of status, first the case goes to the service center, and then it goes to the local USCIS office for final adjudication. At the service center, one of the things they do is make sure the person meets the requirements for the affidavit of support. If they don't meet those financial requirements, the service center will send a request for evidence, an RFE, asking for more financial documentation. If the person doesn't send those documents, the case will be denied for abandonment. It won't be denied for public charge, so you'll get an underreporting of public charge for those adjustment of status cases. Very similarly, for somebody applying for an immigrant visa at the consulate, first the case goes to the National Visa Center, which collects documentation, and then it goes on to the consulate. Very much like the service center is going to send an RFE if you don't meet the financial requirement. That is what the NVC will do. And if the person doesn't respond, doesn't send the documents that were requested, it will be not really denied, it will be terminated for abandonment. And again, that will not appear as a public charge denial. It will appear as a termination for abandonment. It may not even be included as a denial. It would be a termination. So that is going to mask the number of actual public charge denials. Also, I looked because the NVC hasn't always done it that way. It used to be that you would bring your documents directly to the consulate and the NVC wouldn't make that initial request for evidence. And I'm a little limited on the data because it doesn't go back before the year 2000 on the Department of State website. But I got some of the numbers from 2000 and 2001, and then it was around that time that the NVC was doing more of the work. And public charge denials at the consulate in 2000 represented 16% of the total final denials for cases for immigrant visas. And in 2001, it was 8%. That may not have been completely representative, but it may give us a little bit of a better idea of what the actual denial rate is. This number, it accounts for less than 1% after 1950. That is very misleading. I would even go so far as to say it's just false. So when Vox implies that public charge inadmissibility is obscure or has been in the past, that is very disingenuous. It is not obscure at all. It's actually a very big deal. The other thing that Vox and all of the other articles are leaving out, which is very important, is the failure of the affidavit of support system. You see, when the law was overhauled in 1996, both the public benefit law and the immigration law, they created a new affidavit of support, as I described, that has to be filed by the sponsor. And what it's supposed to do is create a binding contract that the sponsor will provide financial support to the foreign national if the foreign national falls into financial distress, so that that foreign national isn't going to get the money from the US taxpayer. And if that person does go and get the money from the taxpayer, then the state or the federal government can actually sue the sponsor to get the money back. So part of why during the Clinton administration they relaxed that second part of the rule, is there something about you that makes it so that you're less likely to be able to support yourself? They relaxed that part of the rule because they believed the affidavit of support would solve it. Back in 2007, which would only be about a decade after the new affidavit of support system, the state of Connecticut tried to start suing sponsors on the affidavit of support to recover the money that they were giving to immigrants through public benefits. But there was a huge public backlash, probably from only a segment of the population. I think we've all seen that happen. And the state actually backed down. And since then, most of the states have decided not to try to pursue it, not to try to take it to court because it was too explosive of an issue politically. There's also been some legal opinions over whether these affidavits are really enforceable at all. Throughout the Obama administration, it was clear that something was going to have to be done because the affidavits of support weren't working. Nothing was done. So now in the Trump administration, they've decided, okay, well, the first prong of that test isn't really doing what it was supposed to do. We're going to look more at the second prong of the test. And my legal opinion is that is consistent with congressional intent. And it's been pointed out in a number of the articles that immigrants receive public benefits at the same rate as native-born Americans. Congress intended for immigrants to get public benefits at a lower rate, and in fact, a much lower rate than the general population. It's very clear from everything Congress was doing in the mid-1990s, everything they said in congressional testimony, etc., that they wanted immigrants to get public benefits at a lower rate, at a much lower rate than native-born US citizens. So if the rate is the same, then it's contrary to congressional intent. This new public charge policy brings us closer to congressional intent than the previous policy, largely because of the failure of the affidavit of supports. That's all for today. I'll see you next time. Thanks for coming.